Thank you. I'll have Adrian.
Thank you everyone for coming. We will start the session. We have Janice and Leo who will be speaking, and she is a partner from Stephen Thiru and Sudhar. Just a little bit of intro. Janice has extensive experience in wide range of employment-related matters, including representative clients at the Industrial Court, judicial review applications at the High Court and appeals of the Court of Appeal and Federal Court. Janice also handles various aspects of employment-related advisory work for both local and foreign corporate clients on issues such as collective bargaining, employee discipline, dismissals, voluntary separation schemes, retrenchment, reorganizations, mergers and acquisitions, and dismissals. Janice is also a committee member of the Bar Council Industrial and Employment Law Committee, member of the Board of Governors of Montfort Boys Town, immediate past secretary of the Catholic Lawyers Society of Kuala Lumpur, Bar Council Advocacy Training Committee trainer, and she is also a member of the Malaysian Society for Labour and Social Security Laws. Today, she is going to speak on the proposed bills on sexual harassment and recognition of social work as a profession. So just if anyone would like to ask any questions, you can put it in the chat box and we'll let her know. Without further ado, Janice and Leo.
Hi, everyone. Good morning. Thank you for joining me this morning. I'll be speaking on two slightly different and diverse topics. One is a discussion on the sexual harassment bill that has yet to be passed. And then we'll have a short discussion on the recognition of social workers as a profession, the importance and the need to recognize social workers. Now, I'll start off by dealing with the issues in respect of sexual harassment. Just a minute. All right. So I'm going to go straight to this slide, which basically tells you now what is sexual harassment. I think I've spoken many times on the issues of sexual harassments and how the courts deal with it and how legislation has moved forward. Now, sexual harassment, as everyone knows very simply, is unwanted conduct that is sexual in nature. It could be in many forms: verbal, non-verbal, visual, gestural, or physical. Verbal, of course, is obvious when you say something that is sexual in nature. Non-verbal could be something in writing. Visual could be pictures. Now, with the wake of WhatsApp and Snapchats and Instagram, there are a lot of people who post pictures that are somewhat inappropriate sexual in nature. Gestural, of course, is making gestures with your hands or your body that has a sexual connotation or that's provocative. Physical, of course, is the most obvious, is when you physically touch someone or assault someone in a sexual way. That is very obviously harassment. Now, we start off with what was enacted in 1999, which is the Code of Practice on the Prevention and Eradication of Sexual Harassment in the Workplace. Now, as you will see, in 1999, the code started with harassment in the workplace. So everything was confined to a workplace environment where it is a unwanted conduct that has reasonable ground of placing sexual conditions on your employment. Of course, it was then expanded to say, look, it need not necessarily have direct link to your employment. Sexual harassment can happen anywhere. So from 1999, all we had was this code. We also had a very challenging culture in Malaysia where a lot of people were not receptive of the concept of sexual harassment. It was always put down to, oh, you know, they're just joking or they're just kidding, unless it's very serious form of physical harassment when someone is groped or someone tries to kiss someone or physically touches someone. Then, of course, people sit up and say, oh, okay, this could be something serious. But until and unless someone is physically assaulted, when it comes to words or sending an email that has got sexual connotation, people didn't take it seriously. Yeah. Now, it took a long time since 1999 uh, for organizations, women's group, for NGOs to move employers to implement internal policies uh, to have zero tolerance towards sexual harassment. It was very slow in the uptake. A lot of organizations didn't think it was necessary. A lot of organizations felt that, look, we can handle it on a case-to-case basis. There's no point going out there and putting and talking about sexual harassment because it's not really something we want to talk about. With a lot of pressure and a lot of moving forward, the amendments were made to the Employment Act in 2012. Yeah. So prior to 2012, if you are looking at my chart here, prior to 2012, incidences of sexual harassment were just managed in a usual way that a misconduct would be managed, where your HR person or your internal audit department would investigate, and a show cause would be issued, a disciplinary proceeding would be initiated, and it goes down the usual route of handling a misconduct, not necessarily confined to timelines, elements of sensitivity, confidentiality. If your organization was sensitive enough, perhaps they would allow you to have that. Otherwise, it was very much on a ad hoc basis. But come 2012, there were amendments made to the Employment Act, and under Section 81B, there was a very limited mechanism on how to handle sexual harassment complaints in a workplace. Yeah. Now, I'm going to take you through very quickly to the mechanism of investigations under the Amendment Act, and we will then deal with how this mechanism was wholly inadequate. Wholly inadequate, did not really provide a proper framework to deal with all issues that come from dealing with a sexual harassment complaint. Yeah. So Section 81B basically says an employer is required to inquire into a complaint, but he may refuse. Section 81B2 says an employer may refuse, and if he refuses, he must inform the complainant in 30 days. So if you look at the time frame here, from the time you receive a complaint to when I'm going to now write and inform a complainant, you are not supposed to, you're meant to do it within 30 days. Problem number one here, don't you think 30 days is a bit far too long for you to inform a complainant who has been sexually harassed that, look, I'm not going to look into your complaint? So we have a time frame problem here. And if you look at the next subsection, the employer may refuse on two conditions, yeah, or two circumstances. One being the complaint has already been looked into and it has been dismissed. Or another time when the employer may say, look, I don't want to, or I will not be inquiring into your complaint, is because the sexual harassment complaint is frivolous, or it's vexatious, or it's not made in good faith. Now, when is a complaint frivolous or vexatious? Is particularly when you find that an employee is making a complaint against a superior because, for instance, she didn't get a good performance rating, or she doesn't, or he or she doesn't get along with the superior, so she's just now making false allegations against the superior. So these could be circumstances when an employer can decide not to inquire. Now, if an employee is dissatisfied with the refusal to inquire, he or she may then refer the matter to the DG. Now, this is a DG of Industrial Relations. Yeah. Now, what does the DG do? I'll come to that very shortly. Now, if the employer has carried out investigation and he is satisfied that a complaint of sexual harassment has been made out, then of course the employer may go ahead and take disciplinary action. Now, this is of course if someone is within your organization. Now, what do you do if someone is not within your organization? So we must understand Section 81 comes under the purview of the Employment Act. So someone not within your employ, you can't really do anything about it. So this again is a limitation to the mechanism provided for in the Act. So if you go for a seminar and someone from another organization who sits next meets you during a conference or a seminar sexually harasses you, it's outside the confines of your organization. You can't quite do anything about it. But of course, in the Employment Act, it says that you can notify the other employer, but what the other employer does about it is completely out of your hands. So they could say, oh, all right, thank you for letting me know, and do nothing. Again, it's out of your hands. Of course, an employee can be advised to lodge police reports and things like that, but not every complainant wants to go down that route. Now, as I said earlier, if the employee is unhappy that the employer doesn't want to inquire, she or he can then lodge a complaint to the DG. The DG will then assess whether the complaint is valid or not valid. And if the DG decides that the complaint of sexual harassment is proven, he can then take certain steps. The DG can also direct the employer to inquire into such complaints. Now, if you notice, I've gone through just a few sections, except for one section where the employer has to notify the complainant that he will not be inquiring, and the notification must be done within 30 days. The rest of the provisions in Section 81 doesn't provide for any form of time frame. It also doesn't tell you how it's done, what sort of mechanisms will be employed by the DG or by the employer, how investigations will be carried out. It's very general. It basically imposes an obligation on an employer to investigate. Of course, we started with there being no obligation. So with the amendment, there is a limited obligation to investigate, but it doesn't really take you far on what to do and how to do it and what sort of time frames. Now, of course, if an employer fails to make inquiries, he or she or the employer commits an offense and there are liabilities that are attached to it. Now, the shortcomings of the mechanism is, as I have been telling you, there's no set time frame. So both the complainant and the alleged harasser could just be waiting, thinking, is the investigations complete? What are they going to do next? And particularly for a complainant, there's a lot of anxiety, because if you don't remove the complainant or the harasser from the working environment, the complainant sits there every day thinking, oh my God, am I going to get harassed? Is he going to come up to me and say something that's going to upset me? So time frame creates anxiety, it creates anticipation of what's going to happen. Now, the second point is the mechanism only applies to sexual harassment in the workplace. And it also applies to those who come within the Act. Say, for instance, people who come, or employees that come within the Employment Act, are employees who earn 2,000 and below. So if you have an employee who earns, say, 2,000 and above, the employer may say, look, I don't have to comply with Section 81 because it comes within the purview of only those who earn 2,000 and below. So that also becomes a very gray area. Is every complaint or every employee given protection under Section 81, or is it just those who come within the Act? Yeah. There's also bullet point number 4, there are no guidelines on how to investigate, particularly in respect of the sensitivity. Now, a complaint of sexual harassment really goes to the dignity and the reputation of an employee. So if it's not treated with sensitivity, it's not given the confidentiality that it deserves, it can cause a lot of psychological difficulties. It can cause a lot of trauma and anxiety. But if you look at Section 81, it doesn't provide for confidentiality or sensitivity in dealing with such complaints. There's also silence in respect of criminal liability, and as you can see, the employer or the DG doesn't really have any powers to do anything. There are no powers to compel, there's no powers to do or to bring the harasser forward to investigate. So it was employment lawyers in 2012 were half thrilled that we had Section 81. And then when we actually looked at Section 31, we thought, oh my God, this is quite sad. It really doesn't cover anything. It just says you have to investigate, and when you don't, what happens? And because of that, the Joint Action Group, the Joint Action Group for Gender Equality, the Association of the All Women Action Society, yes, sorry, the All Women Action Society, and many other women's group came together and said, look, we need to have a standalone bill. Of course, on the converse, a lot of people said, look, disparaging someone or sexual offenses is covered in the penal code. So why do we have to have a separate bill that deals with sexual harassment? Because outraging modesty, sexual assault or assault in sexual nature is covered. Let the criminal justice system deal with issues of sexual harassment. But it was felt by the women's group, and thankfully the ministry also agreed that, look, this cannot be handled under the criminal justice system. Complaints of sexual harassment, investigations, and even prosecution for sexual harassment has to be dealt with separately, has to be dealt with in a complete different mechanism and a complete different system because of the sensitivity of the complaint of sexual harassment. So now I'm going to go into speaking to you about the bill. Now, from 2001, women's group, particularly the Joint Action Group Against Violence Against Women, which is now actually called the GAG for Gender Equality, they have been pushing for this bill since 2001. And if I'm not mistaken, in 2008 or 2010, the draft for the bill was discussed by all stakeholders. Now, as a member of the Industrial and Employment Law Committee of the Bar Council, myself and another colleague of mine from the committee sat at meetings with the ministry, with the women's group, with the unions, with the Association of Employers to discuss this bill. However, at that material time, I trust it was 2008 to 2009, nothing moved. There were long discussions. The ministry got input from all stakeholders, all parties, lawyers, where we sat in women's group that were very good in dealing with all aspects of sexual harassment and all aspects in dealing with complaints of sexual harassment. So finally, in 2018, the bill was finalized by GAG. Now, there were three demands that the GAG made. One was specific timeline for the tabling of the bill, that the bill has to have clear definitions of harassment with best practices, minimum standards, and mechanisms that work. Yeah, mechanisms that work. Now, they also proposed changes to the Criminal Procedure Code that will render court process more sensitive. But I don't think point number 3 was something that they were pushing, because they decided that let the CPC be the CPC, let's handle sexual harassment as a standalone bill, as a standalone act with standalone mechanisms. Yeah. Now I'm going to take you through the bill. I'm going to take you through the changes or the framework of the bill and what you can expect in the event and if and when this bill is passed. Now, the ministry was pushing for it. I know the former Deputy Prime Minister was pushing for it. YB Hanayo was pushing for it. Of course, with the change of government, the current minister had given her word that she would push for it, but right now it's still sitting there. Nothing has moved. And now let me take you through the content of the bill. Now it starts off with defining what is sexual harassment. It goes on to talk about prohibitions. It also deals with issues of vicarious liability. What happens when an employer receives a complaint and doesn't do anything? Liability is also placed on employers on that part. Now, part 4 talks about the duty to formulate policies. This is a duty placed on all organizations, employers, the civil service, statutory bodies. Now, part 5 talks about the appointment of a director of sexual harassment. Now, I'd like to caveat at this point and say that the bill that I'm discussing with you is the bill that was proposed by JAG, the Joint Action Group for Gender Equality. From what I've been told, people who have been involved in coming up or drafting this bill had tabled it or forwarded it to the ministry. So what I've been told is the ministry has made some changes, and that bill that the ministry has been deemed as sulit. So I haven't had chance to look at that bill. I think no one really has. Perhaps JAG has, but that particular bill that is sulit is obviously not for public consumption. So I'm speaking to you today and working with you today on the bill that was proposed by JAG. Now, JAG proposed the Director for Sexual Harassment. The Director for Sexual Harassment is just like your DG of IR, the DG of Labor, is the person who will be in charge of the workings, the mechanisms, the implementation of all initiatives under the bill. Now, what I've been told is the Director of Sexual Harassment, the title in itself is not formalized yet. It could be called Commissioner. Apparently, the ministry had suggested that the person be called Commissioner, so we don't know yet. Now, part 6 talks about the processes, the framework, the complaint, the time frame, what happens when a complaint is received, what happens when an investigation is completed. Then there is a mediation process. The mediation process is just like the Industrial Relations Act, where you have a conciliation process. When there's a complaint for unfair dismissal, there's a conciliation. So here, under the Sexual Harassment Bill, we call it the mediation. Now, after the mediation is completed, and if the mediation is not successful, there's an inquiry by a tribunal. Now, the inquiry by the tribunal is very, very similar to trials being carried out by the industrial court. It's very similar, except the tribunal consists of 3 people, whereas industrial court generally it's just 1 chairman. Now, part 6 also talks about the enforcement of orders or awards made by the tribunal. Now, so that's the overview of the bill. Now, I'm going to take you through the bill and highlight to you critical and important and really far-reaching provisions that has been proposed by the JAG in the bill. Now, of course, you've got the all-encompassing section of no person shall be sexually harassed. Now, the amazing thing about the bill is it's not limited to an employment context. It deals with sexual harassment at the workplace. It also deals with sexual harassment of a person anywhere. So it could be in public, it could be sexual harassment in a private place. So it's not limited to workplace. Now, what is sexual harassment? The definition is as it was in the code in 1999, which is engaging in unwelcome conduct of sexual nature. Now, the conduct of sexual nature, which, as we saw earlier, could be physical, it could be visual, it could be gestural, So this conduct must be offensive. It must violate the dignity of a person. It must create an intimidating and hostile and degrading environment for that person. So the environment need not only be a workplace environment, it could be anywhere. So long as in the confines of the location where someone has been harassed, that environment has been intimidating and hostile or humiliating or offensive. Now, the act or the bill goes on to assist, I suppose, the DG to determine what is the conduct that is sexual in nature. How do you determine the effect that it has? Yeah. So it basically says it's whether the conduct is reasonable for you to infer that it has the effect of it being intimidating, of it being offensive, all those sort of things. Now, in determining the reasonableness or in determining the effect, Section 6C sets out circumstances that you can take into account, which is the gender, age, sexual orientation, religious belief, race, legal status, nationality, ethnicity, the relationship between the harassed person and the person harassing. In the bill, the person who commits the act of sexual harassment is referred to as the respondent. The person being harassed is referred to as the complainant. So these are circumstances that you take into account in determining the conduct that is sexual in nature. Now, as a general rule, to determine whether someone is sexually harassed, uh, the principle or the concept of criminal law called the eggshell skull rule, which is you take your victim as you find him. So why am I telling you this? Is because what I find sexually offensive may not necessarily be what someone else finds as sexually offensive. I may, maybe, I don't know, be a bit more thick-skinned and think, oh, haha, that's just quite funny. I may not be offended, but someone else with a different sexual orientation, with a different um, religious belief or legal status or ethnicity or different mindset might think, oh, I'm very, very offended by that. So it's very, very subjective, which is why this non-exhaustive list has been given to assist to determine what is sexual in nature, what is reasonable. Yeah. Is it fair for it to have that net effect on the complainant? Yeah. Now, some of the very important things that you need to look at is one incident of sexual harassment is sufficient. You see, so you could just someone could send me on WhatsApp a picture of a banana. Yeah, a picture of a banana with a question mark saying, or the word saying interested. It could mean two things. Someone could be offering me a fruit, or someone could be necessarily, being, think that they're being very sexually cute and the word interested. So that one act alone is sufficient to constitute sexual harassment, provided I'm offended by it, provided I think that, look, this is lowering my dignity. So one act is enough. You don't have to have continuous conduct that infers sexual in nature. Now, Section 9, I think, is something that the women's group really, really pushed for because of perception, where there's this perception that just because someone is sexually active, someone has an active sex life, does that mean that they have invited the harassment? Or, so Section 9 basically says anyone's sexual experience or anyone's sexual reputation is completely irrelevant in determining the act of sexual harassment. So this is an anti-discriminatory section. So it says, I'm sorry, just because I've had many sexual partners and I'm sexually active, that doesn't mean I invite harassment. So this is a plus yay point for complainants. Now, the bill also deals with issues of victimization. Now, what is this? So basically it says, if I make a complaint or I lodge a complaint on behalf of someone, or I provide information on behalf of a complainant, or I'm an informant that observed the sexual harassment going on in my office, or I provide, maybe I didn't see it, but I have evidence, yeah, of some form of it. These persons, in the event they are threatened against lodging complaints, or they have lodged a complaint and some form of threat is made to them, they are deemed to have been victimized. And of course, there are penalties in respect of these people who have been victimized. Yeah, so there are protections. Now, Section 12 talks about people who provide information. They are protected from civil and criminal liability. They are given the confidentiality. So this is a little bit what I would call your whistleblowers protection, where witnesses, informants, complainants are protected. So you can usually I've done so many sexual harassment trials, it's so difficult to get a witness, an eyewitness to come forward. First of all, sexual harassment takes place in close confinements, away from eyewitnesses. But even when you have an eyewitness, sometimes they don't want to come. They say, look, I'm not going to tell on my superior. I'm not going to tell on another colleague. Look, this doesn't involve me. I don't want to come in the event any action is taken against me. So this is protection given to informants, given to witnesses. Section 13 again says there's no personal liability for lodging a complaint or giving evidence under this bill. So there's a lot of protection for informants, for witnesses. Now, this is very important for employers. In the event employers do not investigate, do not take action, or do not provide some form of redress to an employee, the act or the bill says that you can be vicariously liable for the complaint of sexual harassment. You could also be vicariously liable for being in breach of provisions of this act. So it's very serious. Yeah. Now, an employer who goes ahead and carries out investigations, takes action, or particularly an employer who takes precautionary action when a complaint has been made, no action, they are exempted from liability. Yeah. So when you receive a complaint as an employer, you got to do something. Yeah. If you don't, you can be vicariously liable. Now I'm moving on to the next bit, which is a duty or an obligation on individuals, institutions, employers to formulate policies to create a harassment-free environment. Now, previously, like I said, there was a very, very slow uptake, very slow uptake on employers wanting to come up with internal policies. Yeah, because everyone just said, oh, no, no big deal. It's not really a big problem in my organization. But now there is a duty imposed by the act or the bill for you to create these policies. Yeah. Next is the appointment of the director and the tribunal. Now, the director, Section 21, appoints the director of sexual harassment, and he or she shall have the power to control and supervise all matters under the bill. Now, what does a director do? You are required to, of course, come up with policies. You are required to advise and recommend on all matters relating to the act, to promote policies and practices, disseminate information in respect of good practices in dealing with sexual harassment, to investigate. Now, I'll deal with you shortly and on the powers of the director to investigate, how the director is involved in the mediation. So the director of sexual harassment actually has a huge role in getting his or her hands dirty in dealing with complaints of sexual harassment. Now, Section 28 deals with the establishment of the tribunal. The tribunal, like I said, is akin to the industrial court. It consists of one chairperson. The chairperson shall be appointed by the AGO. They pick from legal practitioners, not less than 7 years standing, or a sessions court judge, or former judges, or former judicial commissioners. These people can be appointed to sit as a chair. Now, members of the tribunal are representatives of NGOs, representatives from the private sector, experts in the area, representatives from people of marginalized groups. This could be your women's group, this could be various other organizations. Yeah. So this is the constitution of your tribunal. Now, as you can see, this is the procedure. A complaint is lodged. After the complaint is lodged, the director will investigate. Then there is a mediation. After the mediation, in the event some sadly it's not successful, it gets referred to the tribunal. The tribunal will then hand down an award. So this is the new process. Yeah. So if you can see, compared to what we have currently, which is Section 81, it doesn't cover all of these issues. It just says you can inquire. If you don't want to inquire, what do you do? If the complainant is unhappy, she goes to the DG. What can the DG do? It's not all encompassing at all. And the bill attempts to make it all encompassing. Yeah. Now, how do you make a complaint? Section 30 says you can complain in writing. What you need to do, as one would necessarily assume, you need to set out the details of the act of sexual harassment. If you don't know how to draft this complaint, the director may actually assist you in making a complaint. Now, what sort of complaints are we looking at? The bill basically says the last act of sexual harassment, it must be made within 6 years. So this is your usual limitation period. If you want to lodge a civil complaint, you must do it within 6 years. So the complaint, the last complaint must be within 6 years. So if you make a complaint, say the last act was in 2015, but anything that happened before 2015 can be included, but the last act must be 2015. But as necessary, there's a lot of flexibility given to the director. Any complaints that are after, long before the 6 years, can be taken into account if it's reasonable. So there's a lot of flexibility given to the DG, not the DG, the D, he's just the D. You will see even later when I deal with withdrawals and dismissals of complaints, how a lot of flexibility is given to the director. Yeah. Now, Section 31 deals with the procedure of a complaint. Now, within 14 days of receiving a complaint, the director shall extend the complaint to the respondent. The respondent is basically whom we call the sexual harasser. So within 14 days, a complaint is given to the respondent. Sadly, it doesn't really say, you see, the next slide, I jumped to Section 33, but Section 32 doesn't really say how many days does the respondent have to respond, what happens when the respondent responds. That very detailed mechanism is not provided. Subsequently, you will see that the DG, that the director is given the authority or the power to investigate and carry out investigation in a manner that he deems appropriate or reasonable. So the first time frame we have is within 14 days, the respondent is informed. Yeah. Now the complaint may be withdrawn by the complainant. Now, of course, when the complaint is withdrawn, the complainant must give a statement of reason. So you can't just say, look, just like an industrial court case, you can just say, look, I don't want to pursue anymore, I withdraw. Here, you can't just withdraw, you must give reasons for such withdrawal. Now, even if the director receives such a withdrawal, the director may say, look, I'm not happy with this withdrawal, I'm still going to go ahead and complain. The director may do so if the director feels that the complainant has been coerced to withdraw, or the withdrawal obviously was not voluntary, or it is in the public interest to carry out this investigation. There could be a lot of pressure on a complainant, and the complainant may feel, look, I don't have the tenacity to go on, I don't have the gumption to go on, it's just too much pressure, too much stress. You know what, forget about it. So the director can then say, look, fine, you withdraw, but I'm going to go ahead with my investigation because it's in the public interest to do so. Yeah. And this is what I was talking about. Section 34 says the director shall investigate a complaint in any manner that is appropriate. So 14 days after receiving a complaint and up to 30 days when the investigation must be complete, the director can carry out the investigation in any way he or she deems appropriate. Now, one very, very good thing, Section 35 allows the director to issue IPOs, interim protection order, particularly when a complainant has been harassed or assaulted or threatened by the respondent. So you can go to the director and apply for an IPO, and the director has 7 days to decide whether the request for an IPO is for good reasons, whether it's frivolous, and within 7 days, the director must inform or notify the complainant or the respondent that one, the IPO is being issued or not being issued. So that decision must be made within 7 days, yeah? And the interim protection orders, the IPOs, are enforceable as an award of court. So it has got some force, and there are penalties for not complying with the IPOs, and we'll deal with that later. Now, Section 36, the director may also dismiss a complaint. So earlier, 33, we dealt with withdrawals. In Section 36, we deal with dismissals. So if the director, in the form of, in the course of investigation, of course, writes to the complainant and to ask for more information or engages the complainant in the form of investigation. However, there's no response. Yeah. So if there's no response from the complainant for a period of 60 days, and this is a fairly long time frame, 60 days, the director may dismiss the complaint. So when the complaint is dismissed, the director shall notify the complainant, and the director may reinstate only if there are very, very reasonable circumstances. The director may reinstate a complaint that he or she has dismissed. Yeah. Section 37 says that the director is to complete the investigations within 30 days. So you can see from the time a complaint has been received, the powers to investigate, the director is given powers to issue interim protection orders. They have the power to withdraw, power to dismiss. So there's a lot that is legislated. There's a lot that's legislated in respect of the powers of the director. Now, once the director has completed the investigation, my reading of the bill, it would necessarily mean automatically it goes to mediation. Because if I'm just going to go to the previous slide, it says, Section 37 says, the director to complete the investigation within 30 days of receipt of the complaint. And the very next section goes into mediation. So one would assume that the mediation is automatic after an investigation is carried out. Now, at the mediation process, parties are to represent themselves. No lawyers, no advisors, no consultant, just like the conciliation process under the IRA. Yeah. However, complainant may be accompanied by a friend or a family member, but the friend or family member does not have the right of audience, so you can't speak. So if I go for a mediation and I bring, say, my brother with me, my brother is just there as support. He can't speak, he can't address the mediation process or the mediator, nothing. Yeah. Section 39 says, another timeline, the director to appoint a qualified mediator to resolve the complaint within 60 days. A mediator is to be appointed within 30 days. So you've got 30 days to appoint a mediator, and a mediation is to be completed within 60 days. If you ask me, I think the time frame is too long. In all honesty, why do you need 30 days to appoint a mediator? I would assume that there would be a list of mediators already available to the director. So the appointment of the mediator, I don't see why you need 30 days. Perhaps 14 days could be sufficient. And mediation to be completed within 60 days, that's also really quite long. So I suppose the time frame given here is intended to cover high number of cases, high number of complaints, backlog of cases. My personal view is 60 days is very long. Like I said, the ministry came up with their own bill, or they made slight changes, I've been told. So I don't know whether the time frame has been changed, but this was the proposal. Yeah. Now, section 40 and 41 talks about a successful mediation. So what happens if a mediation is successful, just like a conciliation at the IR department, it will be recorded as an agreement, and it is to be enforced as an award of the tribunal. Yeah. So an IPA is also to be awarded, enforced as an award. Mediation agreement is also to be enforced as an award of the tribunal. Yeah. Now, also similar to conciliation process, the proceedings during a mediation cannot be admitted in any subsequent proceedings. For instance, if we go to the tribunal, now I'm coming to an inquiry by the tribunal, whatever happens at the mediation cannot be admitted as evidence at the tribunal, which is again very similar to the conciliation process that we have in the Labour Office. It cannot be admitted as evidence at trial before the industrial court. Yeah. Now we go into an inquiry. So we've had the receipt of a complaint, we've had the investigation, we've had the mediation. Now, after the mediation, the matter goes to court, the tribunal. Yeah. Now, the director shall refer a complaint to the tribunal if he feels that complaint cannot be resolved by mediation. So look, let's not waste time. Let's just go straight to the tribunal. Or the mediation was not successful. Or C, if you look at C, believes that the nature of the complaint is such that it should be referred for inquiry. It's very vague. It's also very general. So how do you determine that the complaint should be referred to an inquiry? How do you determine that something should go directly to an inquiry? We don't know. I mean, that's for the director to determine. Yeah. Now, D is if it's requested by the complainant. So this necessarily means the complainant can say, look, I'm making a complaint. I want this to go straight to court. How does that work? Does that mean you don't investigate, or does that mean you don't mediate? It's general. It's vague. Yeah. How does the complainant request for it to go to tribunal? Now, the complaint to be referred within 3 months from the date of notification under section 37. Here, there is some form of confusion, because if you look at section 37, and I'm taking you to the slide that deals with section 37, it says the director to complete investigations within 30 days. So there's no indication of a notification. So I would then maybe assume that when an investigation is completed, parties are notified. So the complaint to be referred within 3 months of the notification under section 37, which means within 3 months of conclusion of an investigation. So there are timeframes, there are some form of moving forward, if you can see with the bill, but there are also some confusion or some gray areas that maybe need better clarification when the bill is tabled, or when the bill is better maybe discussed. Now, referral of inquiry. Now, when a matter is referred to the tribunal for inquiry, it must be accompanied by a statement of case. This is also similar to the statement of case that is submitted or filed by a claimant in the industrial court. Now, again, similar to the industrial court, it's on a balance of probabilities, and the burden is on the person who raises an issue. Nothing changes here. Now, what is interesting is the bill specifically provides that for a complaint for sexual harassment, there is no need for corroboration. So in a lot of industrial court cases where the courts have gone on to say that corroboration, in Janice holdings, they said, look, you need corroboration. Subsequently, the industrial court recognized that it's not easy to have corroboration. Yeah. Then they went on to say corroboration is good, is encouraged. Corroboration strengthens your case. Yeah. But the bill now goes on to say, look, sexual harassment complaint, you don't need corroboration at all. So that's quite definite. Now, in dealing or in concluding an inquiry, the tribunal has a lot of powers. Look at the list of remedies, my friends. A, the respondent must not repeat the act of sexual harassment. Basically, this is some form of an injunction for you to stop. B, respondent must redress any loss or injury, yeah, caused. So how do you redress? Later, you will see that there is also provisions for apologies and retractions. Yeah, the respondent must employ or re-employ or promote the complainant. Of course, these are all based on the facts of each complaint. So if an employee, if there been some form of sexual harassment in the course of employment and the employee then leaves, you are required to re-employ them. The respondent must pay the complainant some form of damages for physical, psychological loss or injuries suffered. This is not limited to losses of wages. Yeah, there's also a provision for exemplary damages. I can just imagine the extent of a psychological trauma or psychological sexual harassment uh, has made way, perhaps the Tabung Haji case, where the federal court recognized the tort of sexual harassment and exemplary damages were allowed. The bill has now also recognized that. Yeah, so the contract or agreement may be varied. So different remedies for different set of facts. But at the end of the day, if you look at G, I want to highlight G to you. If the respondent's employer is a party, the respondent, if an employee, the court or the tribunal may make orders that the respondent be disciplined, be demoted, or even be dismissed. And if so the question that I have looking at the bill and looking at this particular remedy is, if a person, a complainant, has been sexually harassed and makes a complaint to the employer, does it necessarily mean that the employer no longer has to investigate a complaint of sexual harassment, because the employee or the complainant can go directly to the director and complain under the mechanism provided for in the bill or subsequently the act? So when it comes to complaints of sexual harassment, an employer need not get his hands dirty and deal with it, because anything is then pushed or siphoned out to the director of sexual harassment. Now, that is what I was thinking when I was looking at the bill. Oh, so look, employer doesn't have to investigate because you have powers to discipline, powers to dismiss. Yeah, so that's a question there. Now, again, one of the remedies is any appropriate action that can be taken. They can be referred to receive counseling. So you can see that the remedies here are really, really quite extensive. Previously, the amendments to the Employment Act had no remedies whatsoever. Well, there were penalties and the need for you to investigate, but there was absolutely no remedies. Yeah. Now, is this adequate? Is the bill adequate? I think it covers a lot of instances, a lot of circumstances that were envisaged by the women's group, envisaged by the ministry. It has timelines. It gives the director a lot of powers. Nothing is perfect. No act or no bill that has been tabled before Parliament has been perfect, but I think it's a step in the right direction. It is a step in a holistic direction where complaints can be made, there are protections given, there are remedies that envisage so many circumstances. So I think the bill is a step in the right direction. So what's happening to the bill? It's still sitting there. It was scheduled to be tabled by Hannah. With the change of government, Mina Omar has said that she will, but it hasn't happened. The women's group are pushing for it. They have been putting a lot of pressure, but of course with the pandemic, This has been placed on the back burner. We've got bigger problems to deal with, although the NGOs have come out and said, look, we don't really care about the change in government. We have concerns about the pandemic, but really, if everything else is business as usual, this bill should be tabled again as business as usual. So that's all that I want to speak about in respect of the bill. There are so many things, so many new things, so many changes, and so many implementations in the bill that are progressive, that are supportive, and we can only hope that it gets tabled real soon. Yeah. Now I'm going to move on very quickly to speak to you about social work, which is something very, very different from what sexual harassment is, of course. Now, what is social work? As we all know, social work, here there is a definition or an explanation given by the International Federation of Social Workers. I'm not going to go and read this entire definition. You can have a look at it. But to me, social work started off long time ago, meaning to be philanthropic, meaning to be voluntary response to social issues, voluntary response to dealing with social welfare, human rights, social sciences, those sort of issues. Now, social workers around the world, internationally, and also Malaysia. Now, the problem with social workers is they are an underachieving group of people. Not that they are underachieving, they were looked at as underachieving. Their potentials were looked at as, something someone does because they have a calling. They are unregulated. It was unrewarding because community looked at it as, someone who has extra time and they are on their hands and they can go out and help people. Now, it starts off like that, but that's really not what social workers do. It's unrewarding, or unrecognized to some extent. Yeah. Now, despite the call for high elevation of social work, for the long time, it remained unrewarded, it remained unregulated, or unrecognized even. Yeah. But at the turn of the millennium, I'll be very honest with you, my friends. When I was given this topic to speak on by the organizers, in as much as we all know social work in a very general, ad hoc manner, I didn't really understand the problems or the issues, the real problems or issues faced by the Social Workers Council or the Social Workers Organization, until I read this article. If I can find it, yes, if I can find it, sorry. There was this article written by two persons from the School of Applied Psychology, Social Work and Policy of University Utara, Malaysia, called Professionalization of Social Work in Malaysia Through Legislation. Again, this deals with the Social Workers Bill. Yeah. Now, the Social Workers Bill, I tried high and low to locate it. I've been told that it is sulit. You can't find it anywhere. It sits with the Welfare Department and the Ministry, and you can't find it anywhere. So all I could rely on is the literature that I could find on the net, and this amazing article written by these two persons from University of Utara, Malaysia, which talks about the problems faced internationally, globally, and particularly in Malaysia. Now, what I began to understand from my reading is at the turn of the millennium, there was this concept of bourgeoising social work. When I read this article, I thought, what on earth does that mean? So it was a concept of elevating social work. So people started off doing social work as a passion or as a vocation, as a calling, to serve, to help. But at the turn of the millennial, people decided, no, social work is amazing. Social work needs to be elevated. Social work needs to be put on a pedestal, and it needs to be recognized. It needs to be regulated to ensure the same sort of service, the same sort of assistance is given by everyone who calls themselves a social worker. Now, if you can see the slide that I'm looking at talks about the need to recognize social work as a profession. Now, the professionalization of social work would, excuse me, bring about laws and licensing procedures to establish who can be a social worker, who is a social worker. Now, you may ask me why. What is the big deal? In my bullet point number 2, I set out the need to do it is, one, to ensure certain standards of professional behavior is maintained, to ensure certain standards of code of ethics is complied with, to increase accountability of social workers, and also to maintain a certain standard. I think the most important thing is maintaining the standard of services provided by social work. Because, like I said, it started off as a calling or someone who is very passionate about helping. So everybody, if you group people who are passionate about working and say, look, go forth and help. Different people have different predispositions. Different people have different skills, different characteristics. So the assistance rendered is really very different. So just like having a group of lawyers and having the Bar Council regulate us and maintain certain levels of competency, certain levels of experience and skill, qualification, that is what the professionalization of social workers is really all about. Yeah. So the next slide also talks about encouraging more people to become social workers by recognizing it as a profession, giving it the status that it really necessarily deserves. So when you professionalize social workers or social work, it becomes more palatable, or it becomes more attractive to people to say, hey, look, this is also a form of profession, and not just doctors, lawyers, engineers, accountants. You know, social work is something that has got an amazing status, along with the compensation that comes with it. And I'll talk to you about that shortly. Now, look at the ratio of social workers to members of the public in Malaysia. To 8,756 members of the public, there's only one social worker. That's really, really very few people. In the USA, every 490 Americans, you have one social worker. Australia, double that, 1,100, you have one social worker. Singapore and the UK, even more than Australia, every 3,000 Singaporean has got one social worker assigned or existent for them. By giving it the status that it deserves, perhaps we could encourage more people to take up this vocation, well, no longer a vocation, but take up this as a profession. Now, let's look at the framework in the other countries. Before I go ahead and talk to you about this, I want to talk to you about what I said earlier, the bourgeoising of social work. Yeah, what does that mean? Bourgeois, as we know, means a high status or a proud characteristic. So bourgeoising of social work must necessarily mean elevation of social work. Yeah. Now, at the turn of the century in Europe, there were 6 criteria presented or spoken of to recognize social workers, social work as a profession. One was academics. Now, Academic goes towards qualification. So meaning if you want to be a social worker, you need some form of training, some form of tertiary education, some form of academic qualification to become a social worker. Now, second one is what we call to commoditize social work. What does that mean? To treat the value of social work as a commodity, meaning fair value for the fair work, to compensate, and not just treat social workers in a charitable manner. Next, to institutionalize. So you've got academics, to commodity, to commodify, and to institutionalize. Institutionalize meaning what? To regulate, to register, to be able to supervise and to be able to monitor, just like what the Bar Council does for lawyers. It supervises us, it monitors lawyers in carrying out their services. Yeah. Next is unification. Number 4 is unification. What is unification? Is basically common code of ethics, common standards under which social workers are meant to carry out their services. Licensing. Yeah, licensing goes hand in hand with regulation. It goes hand in hand with academics. You can't just wake up one day and say, I'm going to study the philosophy of social work and I'm going to be a social worker. You need to be properly licensed, just like doctors, just like lawyers, just like auditors. You need to be licensed. And a monopolization of social work, meaning only licensed social workers can carry out social work. Now, you have academics to commodify, such a tongue twister, to institutionalize, to license, to unify, and to monopolize. So these were the 4 criteria that it was felt needs to be met to turn the vocation or the calling of social work into a profession. Now, a lot has happened in the United Kingdom, in New Zealand, and in Singapore. I'm not going to go into this in detail. I've given this write-up for you to basically show that in these 3 countries, it has been somewhat legislated. So you've had the concept of academics. There is a concept of institutionalization, unification, licensing, and to some extent, monopolization. So you have regulation and all of that in many different many different countries. In Malaysia, so I'm going to go to Malaysia. Proposed Social Workers Protection Bill. The Social Workers Protection Bill, I have not had sight of it. I've had some literature on it. Now, the thing with the bill, which was supposed to be tabled in 2019, it was also supposed to be tabled last year. It has not been tabled. I've been told that the Malaysian Association of Social Workers have really been pushing hard for it. But it's still sitting there. Now, the Malaysian government has approved 6 measures to enhance social work as a profession. 1, the establishment of the social workers, the National Social Work Competency Standard, the enactment of the Social Workers Bill, which is the bill that, as I have said, is being pushed by the Malaysian Social Workers Association of Social Workers, the recruitment of qualified social workers, the establishment of the National Social Workers Regulatory Body. So the government has really proposed a lot of things. The standardization of the education system to be a social worker, yeah? So if you look at the key features of the bill, established a regulatory body in the name of the Malaysian Social Workers Council that undertakes the task of registration, licensing, complaints, discipline. This is like the Bar Council, yeah? It deals with the registration of social workers. It deals with granting license to qualified social workers, complaints against social workers, disciplinary action to be taken against social workers. It also deals with continuing professional education. So you're not stagnant. So you are always appraised at the changes in how social work can be carried out, policies that are to be implemented, professional development of social workers in the country. So this council would really regulate social workers, and it would be so welcoming if and when the bill is passed. Of course, the council members, point number 2, deals with who will sit in the council. Now, item number 3 is again more important. The proposed bill will set social work qualification, tertiary education. Yeah. So the tertiary education, which is a bachelor's degree in social work or an equivalent, practitioners who want to be recognized and carry the title social workers are required to register. Yeah, earlier we talked about registration. And if you want to carry out, now, one of the problems raised or identified by the people who wrote the article from University Utara, Malaysia, is qualified social workers and experienced social workers. Yeah, and I will speak to you a little bit more on the next slide, meaning people who have the academic qualification and are somewhat registered, well, not necessarily registered, maybe recognized, yeah, recognized social workers. On the other hand, you have people who are experienced social workers. So if you are experienced and you've just been carrying on social work as a passion, you've got 2 different types. So they've come to recognize one would carry the title SW, social worker, meaning you are academically qualified, you are registered, you are licensed. Now, you also have someone who doesn't have the academic qualification, but you are registered. You want to be registered. You can register yourself as an associate social worker. So associate social worker is someone who comes with years of experience, but perhaps not someone who's academically qualified, what we would call someone with rank and file, yeah, within the mechanism of doing social work. Now, these are the sort of issues that the bill envisages. Now, if you look at the idea of registration, the nature of regulation is mandatory registration. Every person that wants to do social work must be registered with the council. Yeah, of course, there's what they call the sunset period. So people who have been carrying out social work as who have experience doing it but are not accredited, who are not licensed, who don't have tertiary education, time frame is given. Yeah, time frame is given for you to register yourself as an associate social worker and to even undergo accreditation, social work training. If you carry out certain accreditation or training, you could be upgraded to a qualified social worker and not just remain as an associate social worker. Now, how do you determine the concept of competency? How do you determine qualification, whether it's a diploma or a certificate or any other form of tertiary education before you can be accredited? Again, the authors of the article from University Utara, Malaysia, say that all this is so gray, all this is so unclear. Who determines what sort of qualification? And looking at the universities, they also recognize that in Malaysia, only very few universities provide for some form of academic or tertiary qualification in the philosophy of social work. It's very, very inadequate. So how do you determine? So that is one of the issues that the bill is looking at addressing. Now, point number 5, again, you must be licensed. Yeah, you must be licensed. And in renewing your license, again, just like the medical profession, just like the legal profession, you have to go for continued continuing professional education, which means all social workers, associate social workers must collect CPE points. This is also envisaged in the bill. Now, we have the Malaysian qualifying agency, that basically says, look, these are your minimum tertiary entry level, academic level for various professions. So the bill also encourages work or partnership with the qualifying agency to say, look, help us provide guidelines to create the tertiary qualification, the academic qualification, or the training, the vocational training for you to be accredited as a social worker. So these are the various issues that the bill is looking at. Everything, my friend, goes back to the 6 criteria that was envisaged at the turn of the century in more advanced nations that have come to recognize social workers as a profession. And I will end by repeating it for you. Academics, commodification, institutionalization, unification, licensing, and monopolization. So by elevating social workers with academics, with licensing, with registration, not only do we guarantee competency and qualification, we also ensure that the service provided by social workers is of high standards, and social workers are given the standard and given the status that they deserve to be recognized with. That's all I have on the proposed professionalization of social workers. And I think my presentation comes to an end. Thank you very much. I'm very happy to take questions if there's any.
Hi, anyone does anyone have any questions? I see. Everyone's quiet today.
Yes, everyone's quiet. I'm just hoping that I was clear as possible in dealing with the bill and the professionalization of social work. Now, if you don't have any question for me now, but if you have any questions or any questions pop to you later, the organizers have my email. You can contact me via email and I'll be happy to address any of the issues that you have, particularly with the bill, which is definitely something within my purview, but I can help with any clarification.
Can the participants get a copy? Are they allowed a copy of your presentation? We will email them out that.
Yes, most certainly. You can have a copy of my presentation. I've made references to the bill, the proposal by JAG, which is not sulit, so it's all right.
Okay. So does anyone has questions? All right. Thank you, Janice. Thank you everyone for attending. If you have any questions, again, you can just email us and we'll revert back to Janice. Thank you so much.
Thank you very much, everyone.
Thank you. Thank you.
Thank you.
Thank you.
Bye. Have a good day.
Bye.